I think we can just have. All right. A very warm welcome to millions of our viewers globally watching us live, world over on various live streaming platforms, YouTube, Zoom, Facebook. I want to greet you good evening, good morning, good afternoon, depending on which part of this world you are in. Bonjour, bonsoir, Susandria, buonasera, bona daisa, jambo, karibu, dumelang. All right, kunjani. Welcome, ladies and gentlemen. You have been patient for this moment, and at last it is here. The hour is here. Most importantly, a very special thanks to our distinguished legal expert panelists for joining us today from 5 continents all over the world: United States of America, Africa, Europe, South America, Asia. We thank you very much for being able to find time during these very difficult conditions of COVID-19 and to be able to join us at this critical time. We thank you very much, and thank you very much, our expert panel. Today's topic of discourse is the International Criminal Court. We're examining prospects and challenges. The International Criminal Court, prospects and challenges. I am your host today. I'm Professor Dr. Advocate MILTON. I hold a PhD in International Criminal Law, and I am the director, the founder director of Center for International Criminal Justice Africa, which is hosting this panel today. I'll have to introduce the panel shortly, but I'll indicate that we have some of our panelists on the way and might be joining us shortly. We haven't received any information, but anyhow, we already have a very powerful quorum, and we'll be able to proceed. Okay, I'm going to introduce the panelists, the experts who have distinguished themselves internationally in the realm of international criminal law. World over, they are recognized individuals, they are recognized scholars, they are recognized lawyers that the world can be able to listen to. You are very fortunate today to be able to listen to them as they grant their view of the aspects of the International Criminal Courts. I'll start off with the lady in the team, Professor Dr. Alessandra Lanciori, PhD. Welcome, Prof. It's nice to see you with us. Thank you so much for taking your time to be with us. Professor Dr. Alessandra Lanciori, PhD, is an alumni of the University of Perugia. That is Perugia. Yeah, all right, that's correct. In Italy, in Europe. She's joining us right the whole way from Europe. She's a professor of international law, and she has expertise in areas of international criminal law, which is, of course, a subshoot of international law. She's also well established as an authority in areas of private international law. She has all the respect in respect of the subject of EU law, European Union law, and a lot other areas that she's been teaching for the past 2 decades, over 20 years, producing international lawyers. This is awesome, Prof. She's also the chair of the international law within her institution, and Professor Alessandra, Dr. Alessandra, has published widely in the realm of international law and international criminal law. It's a pleasure to have you, Professor Dr. Alessandro, and we know that you are being watched world over on all the continents, millions and millions of our viewers online right now, and they've heard what you're capable of doing. And so it's nice to have you on the panel. And as I said, these are distinguished scholars and practitioners world over who have the respect of the entire legal fraternity. Okay, thank you very much for being with us, and we hope the COVID-19 pandemic has not ravaged your area so much. We've heard about Italy, and I hope all is well. It's nice to see you with us in those circumstances. Thank you, Prof. Ladies and gentlemen, I'm going to introduce to you the next distinguished panelist, well-established practitioner within the fraternity, international fraternity. It is none other than an international expert, specialist, attorney at law, Arthur Traldi. You can just raise your hand so that they're able to see you. Thank you very much, Attorney Traldi, for getting time to be with us the whole way. You are in the United States, right?
That's correct, yes.
Good.
Thank you for having me.
Great, great. It's nice to have you more. All right. Attorney Traldi, Arthur Traldi, is a co-chair of American Bar Association's International Criminal Law Committee. Within the American Bar Association, there are several committees, and one of them deals with international criminal law, the aspect of our discourse today. He is actually the co-chair of that committee in the United States of America. So he's extinguished himself and earned his position, his level to that position. The other thing we need to know is an alumni of Georgetown Law School, Law Center in Washington, DC, District of Columbia in the United States of America. Arthur Traldi as well is a certified practitioner. He practices within the state of Pennsylvania, that's right. He has a license to practice within the state of Pennsylvania in the United States, as well as the whole way to the hierarchy of the the United States Supreme Court. He has practiced for a vast period of time, and he has distinguished himself as an excellent practitioner and defender and an advocate of the rights, championing the rights of the oppressed. The other important aspect of his practice revolves around the Kosovo Specialist Chambers. All of you are aware of Kosovo, the battleground, and he is actually one of the counsel in those chambers, one of the few counsel that appear in those chambers, and is internationally recognized as an expert in the law and litigation related to human rights. And as he says, he deals with not just serious crimes, but very, very serious crimes. That is his area of litigation. So if you are confronted with that, you need to look around and see who deals with very, very serious international crimes that have caused atrocities, which is one of the areas of our discussion today. Actually, the core point of our discussion today. So he's actually a specialist in international criminal law, world over, respected by his peers, and all of us lawyers respect him for what he has achieved and what is yet to achieve. His trial practice advocacy skills are respected, and everybody recognizes that, including the American Bar Association that has put him within that particular committee of the international criminal law. He also handles issues of rule of law and human rights. He is in fact a regular speaker on issues of international law in many universities and colleges in the United States, not just within the East Coast of the United States, but wherever they would require him to be. And it would please you to learn that he has been in the academia as well. He teaches what he practices. He's been able to teach continuing legal education that is taught to lawyers in practice so that they remain fresh and relevant. And he's been able to train judges, prosecutors in complex litigation matters, not just in the United States, but across the continents. Well over 3 continents. There's a track record for that. So we welcome you, attorney expert Arthur Traldi. It's a pleasure to have you from the United States, all the way from the United States. And our audience, the millions who are watching right now, are eager to hear from you. Welcome, sir. Welcome. Thank you. You're right now in Pennsylvania, right?
Yes, so it's early in the morning here, and I'm just caffeinating
for
the day. So if I'm a little slow for the first couple of minutes, hopefully you'll be patient with me. Thank you for what was a far too generous introduction that I'll never be able to live up to.
Thank you very much. It is well deserved. All right. We had Professor Enzo, Dr. Enzo Finocchiaro. He's just gone offline shortly, but we hope he'll be with us shortly, and he'll be able to join us online. Probably they're having connectivity problems. Okay. So I'll reserve the other introduction for the rest of the other team, the expert teams who will join us shortly. I also have to introduce myself since I'm part of the panel. I am actually not a moderator to oversee all these distinguished people. No, I'm just a host. I'm a host to be able to facilitate the entire process of the individuals who have distinguished themselves within the legal fraternity, and so that we are able to benefit from them. Okay, as for me, the little that I can state about myself is that I hold a PhD degree specializing in international criminal law, and largely my doctoral research revolved around the legal and institutional framework of the International Criminal Court, looking at the concept of positive complementarity and examining its relevance in the context, contextualizing its relevance within the modern times and the experiences that we have. I'm also the founder, chairman, and director of Center for International Criminal Justice Africa, which has hosted this panel. And within the center, we train just like my colleagues, Professor Alessandra and Attorney Traldi. We train lawyers as well. We train judges, prosecutors, politicians, so that we are able to have a concerted approach towards combat against impunity, which is the essence of the International Criminal Court formation. The other important thing I need to mention within the relevance of this context of this panel discussion is that I've researched widely in international law, I've published widely in areas of international criminal law. For my master's, I did international law and international criminal law, and I've had occasion to have masters in the University of Botswana. I had occasion to be in the Caribbean island, the University of the West Indies, Keville campus, where I did public law, and as well, I've had occasion to study for the New York State law course that leads to the practice within the United States. I had occasion to research widely within the think tank in Phoenix, Arizona, the United States, the Goldwater Institute, where I was an expert legal consultant, and I published some relevant works within the context of the United States law, running across the states, the United States as a federal entity, a federal structure. The other relevant thing about myself is that I am an advocate I've been in practice, holding a current practice certificate for over 25 years. Although right now I'm trying to focus on academia and to produce lawyers like my learned colleagues on this panel. All right, so that is the little that I am able to say about myself. And I'm a professor of international criminal law. And now the other issue about the center is we intend to engage the entire globe, because we've seen that the issue of combat against impunity is a global issue. And so we're trying to engage and tap the best brains that we can have, like we have now, so that we're able to move forward in terms of capacity building of all the parties concerned. Thank you very much, ladies and gentlemen. Thank you, distinguished members of the panel. In the absence of our colleagues, as they join us, they'll be able to join us and get involved. But for now, I would like to usher in the discourse. And I consider that before we can embark on serious discourse, I just need to quickly outline salient features of the International Criminal Court to help those who are listening, to help the millions of our viewers, and even among them lawyers who are not well informed about the International Criminal Court. So I'll take about 5 or less minutes just quickly outlining to provide a basis for the panelists to proceed with their presentation. Okay, having dealt with that, I'm going to look at the background of the International Criminal Court. For those who have not had the benefit of the knowledge of the International Criminal Court, I would like to state that the Rome Statute is the basis of the existence of the International Criminal Court. The Rome Statute on the 17th of July, 1998, secured the requisite 120 signatures that meant to bring the treaty into existence in the first instance. Among those who voted for the 120 are those who represented countries that voted in favor of the Rome Statute. It's a treaty that was entered into by the states who favored the Rome Statute. Okay, here we had 7 affirmative, 7 negative voting against the Rome Statute. Those who just went against the Rome Statute were 7, those states, including the United States of America, China, we had Yemen, Israel, Qatar. These ones outrightly voted against the Rome Statute coming into existence. But as our colleague in the panel, Attorney Arthur Taldi, might indicate at some future time or now when he talks, the United States actually signed this agreement. That was at the time of President Bill Clinton, but did not go through the Senate processes, which he may be able to well explain, that would validate a treaty, multilateral treaty. So later the United States pulled out the signature, and we now have a United States of America, powerful without having been part of, not being part of this very important statute. So for a statute or a treaty to come into effect, there must be a minimum number of ratifications subsequent to the signing. And so this ratification minimum was met during the 1st of July 2002. That's about close to 4 years later. And by that ratification, the treaty came into force, into existence. Why is this important? It is important because the International Criminal Court is a creature of the Rome Statute. So the moment the statute was ratified, the International Criminal Court as an institution came into existence. So very fast, I'm not giving a lecture, I'm just setting outline. The court is now based at The Hague. That's where it was established, in the Netherlands in Europe. And it was established as a permanent court, in contradistinction to the other courts that we had before, like the ICTR, the International Criminal Tribunal for Rwanda, the International Criminal Tribunal for the former Yugoslavia, which our colleague Atraldi is very familiar with in terms of practice, of course, in those areas. Those ones were ad hoc courts, the ad hoc tribunals set up to serve a particular function and confined within the limits of a particular territory and individuals. And once their mandate had expired, they became functors official. Now, we'll deal with that at a later time. But for now, it's important just to note that unlike those institutions, the International Criminal Court was meant to be permanent. It was meant to be a last resort court, and it was meant to be complementary to the national criminal jurisdiction. Complementary in the sense that it would only step in to complement what the national jurisdiction, criminal jurisdiction was carrying out. But their condition, this is where the doctrine of, or the principle of complementarity comes in, as our colleagues, Professor Alessandra has taught a lot about that among his students. Complementarity is a condition, actually. It is a condition, a limitation on the International Criminal Court, in the sense that it cannot exercise jurisdiction where the National Criminal Court
No, the connection.
Hello? All right. It cannot exercise.
Can you hear me? Oh.
Yeah, we can hear you. Can hear you, Professor. Are you okay? Okay. So I'll
my connection is not very good.
Yeah. No, it's fine. We'll soon wind it up. So in short, for the sake of our viewers, the International Criminal Court would only get involved where the national criminal jurisdiction is not able to, is unable and unwilling genuinely to prosecute or investigate particular crimes, maybe shielding those cronies, to shield them from responsibility and all that. Okay, so the court focuses on nationality and territorial aspects of state parties. The other important thing to note is that the International Criminal Court has jurisdiction only in respect of certain crimes, international crimes. Serious, the way our colleague Attorney Traldi would put, very, very serious international crimes. And these are 4 crimes which it has jurisdiction over, not any other. One of them is genocide. The other one is crimes against humanity, war crimes, and lately the issue of crime of aggression, which my colleagues will be able to talk about if they get a chance. The structure of the court, very quickly, is such that it has 4 organs. We have the presidency, which is at the apex, which sits with the 2 other vice presidents of the International Criminal Court. We have the chambers, where we have the appellate jurisdiction above the other chambers down. Those other chambers are trial chambers. The trial chambers also take over from the pre-trial chambers. So we have 3 layers within the chambers. The pre-trial chambers, my colleagues will deal with that. This is not the time. The other important point, which will form the basis of these challenges and prospects that we are going to discuss, revolve basically around the trigger mechanism. The trigger mechanism are processes through which a matter, the International Criminal Court acquires jurisdiction or instigated to proceed with the exercise of its jurisdiction. There are 3, basically. There can be referral of a situation case by a state party, and willingly a non-state party could. Number 2, we have a situation where the United Nations Security Council would refer a matter under its, of course, the Charter of the United Nations, refer a matter to the prosecutor for prosecution or investigation. In such a case, they would not look at the issue of nationality or territoriality. My colleagues will be able to expound on that much better. And the last trigger mechanism is where the prosecutor herself or himself gets satisfied that he may proceed with investigations in the light of what they've gathered. And that's called proprio motu trigger mechanism. Proprio motu is a technical term for that. All right, so basically that's how it is. There are confirmation things. I will not talk about that now. But a key feature that I'll mention is the victim participation. It's a very important feature of the International Criminal Court, where we have victims are given an opportunity to participate in the proceedings against the accused persons, and actually even lead evidence that would lead to the conviction of the persons accused before the tribunal. That is how important the International Criminal Court attaches the interests of all the parties so that justice is meted. Another feature is the witness protection. And lastly, there's the positive complementarity, which I think my colleagues might have to shed light on, which is the area I researched on largely, where there's been argument like the first prosecutor, Luis Moreno Ocampo, indicated, the success of the International Criminal Court should not be weighed by virtue of how many cases it has disposed of, but on the contrary, we should look at how many other cases have not been able to come through by virtue of the role of the court. Here, positive complementarity would refer to the court actually getting to encourage and to support the national criminal jurisdiction so that they do not have to flood it with cases. And so my colleagues might also want to talk about the issue of impunity gap, where the ICC actually deals with only high-ranking offenders and leaving the less offenders being dealt with by the national criminal jurisdiction. Thank you very much, distinguished members of the panel, my colleagues. Thank you for listening. I didn't intend to give a lecture. It was just an outline to provide a basis for our listeners and viewers all over the world. Thank you very much. I'll now hand over.
Professor, if I can for a second, I think one of our colleagues is waiting to be let into the room, Giovanni.
Oh, okay. Oh, yeah. I just saw him. It's all right. I'll take care of him. Thank you very much, Mr. Child. Thank you, colleague. I'll allow him in. All right. As that goes on now, I'll hand over to the members of the panel. Any of you, as we said, there's no moderation. We'll give you the freedom to be able to talk to our. Let me get in Giovanni Marotta and introduce him. And after that, we can proceed. Professor Enzo just went off, but we trust that he. Okay.
Hi.
Hello.
Hi, MILTON. Hi.
Hello.
Hello.
Welcome.
Good day.
It's
yes,
nice
thank you.
to
I have some trouble with the connection. It
Right.
was not working well. Yeah.
Oh, all right. No trouble with COVID-19, of course.
Yes, of course.
Thank you. It's nice to see you around. We
Yes.
just did introduction. I would like to introduce you to our millions of viewers right now online who are
Okay.
watching us, and so they get to know who you are. And quickly, I'll be able to introduce you right now. Ladies and gentlemen, we have another distinguished member of the panel, expert panel, and I'm going to introduce him right now. He is Attorney Marotta.
Yes.
Giovanni. Just give me a minute. I sort myself out. Just a minute. I'll be with him. We've been able to introduce our two colleagues. Professor Enzo was in here. I think he's gone out, basically out of connection issue as well. And okay, I'm proceeding now to introduce one of our distinguished members of the panel, and that is specialist expert, Attorney Giovanni Marotta. He is a specialist attorney at International Criminal Court Against Child Kidnapping at The Hague in Netherlands. But of course, he has all, his presence is felt throughout the other continents, in South America, in the United States. He is an expert international criminal defense attorney, and he has been able to attend a number of high caliber institutions in the United States in pursuit of academic excellence. He went to the Global Justice Program at the Washington University School of Law at St. Louis, Missouri, United States. He's also been to School of Law, Case Western Reserve University, Cleveland, Ohio, the United States of America. Attorney Giovanni holds several master's degree, not just one, in international criminal law, which he did cum laude from Granada, and another master's degree from the Universität Utrecht. He has experience stretching over 15 good years, even beyond, actually, in terms of the practice revolving basically around the realm of international criminal law and the rule of law, as well as human rights and international law generally. And the other thing about Marota is that he's an expert in terms of the issue that has attracted the attention of the International Criminal Court, that is the gender issues and the weaker members of our society. That's why he focuses on child kidnapping, which is an aspect of the crime of concern that has caused occasion untold atrocities, untold trauma in traumatized communities. Thank you very much. It's nice to have you, Attorney Giovanni. And
thank you, Professor.
Cheers. All right, now we are proceeding into the discourse part of it. I've given a background, a small outline about the ICC now. Feel free. Any of us could join into the discussion as you feel. If you feel you want to get in, you could just indicate, then we'll allow you in to be able to proceed with the discourse. It's been waited for long, and now is your time. Thank you very much.
Thank you.
Yeah. Where are you right now, just a minute, Giovanni? Are you in Europe or in the US?
No, right now I'm in the US. I'm in Washington, D.C.
All right.
I was supposed, I need to return to the Netherlands to run out the office in The Hague, but you know, under COVID-19, the flights are stalled. So I need to wait. I have to have green light from the authorities so I can travel again and return to The Hague.
All right.
So, so that's the thing. So now I'm running right now the office in DC, but what is shut down also, I cannot go there. I'm working from home. And what we are doing right now, it's our NGO, it's working all the cases related to parental child kidnapping for a start.
Yeah.
And what we are doing here, we have two cases in the U.S. And they are very similar under the way the family law judges here in the U.S. Try to try the cases. So the reason why, and I sent you my presentation that I was going to do was related to joint criminal enterprise.
Yes.
Under my research, well, it's a research because here I'm only allowed to practice law under pro ad vice, in this specific cases because the case I'm managing is from a German boy. So, but it's a really bit. You know, I have very components not only from international law, but from private international law, because it's related. Because the boy was born in Benhaves, Spain, so under EU treaties, he's a EU citizen.
Yeah.
And I'm going to put much louder my volume. Don't hear me?
But that's fine.
Okay.
That's fine.
Yes.
Proceed.
Okay. And his father is from Germany. His mother is from the Philippines. He was born in Benhaven, even though that he has the German citizenship. He doesn't need the Spanish one. And they went to live to the US. There were some, you know, family issues over there. The father of this boy was the only one who has the work visa. There's a visa number special for businessmen, but the mother and the boy didn't have that kind of visa. But under this visa, they can live with the father in the US. You know, marriage goes ups and down, and then the mother decided to go with the boy to other place, and she filed a divorce. But here, the strange thing starts when she files a divorce. She said that she was a legal citizen in Florida, so she can apply for this divorce. And according to the statute law of Florida, it says if you need to prove that you are a legal citizen if you have less than 6 months, and you can file a divorce. But then, under reading the case law of the Florida statute, for be considered a legal alien you for doing this divorce procedure, you need to have your drive license. You need a social security number. It's not only you say I'm living here legally. So she didn't prove that. But the strange thing here was that the judge who received the first judge who received the divorce case, she decided to go on. Then with the our client, with his lawyer, then he presents injunctions motions, and the other ones say, okay, this is not correct, but the court continues, and then they vacated a judge, and then another judge took the case. This new judge, they present, then the father, because the visa was going to expire, he decided to return to Germany. He decided to do all the correct path. So he returned to Spain, and then from Spain he filed the International Child Abduction Convention from the Hague Convention in the Ministry of Spain. Yes. But also here it was very he was if you in this case even in Spain also they're misleading him in a way that when he presents the documentations in the first place, according to Spain, under universal jurisdiction, her mother could be tried in Spain, but the Spanish authority told them that it was not true. But when we received the case and we analyzed it, we said, okay, you can do something in Spain. So we are also working with an attorney in Spain, trying to clean up this mess. And the father present all the documentation according to the Hague Convention, and the U.S. Department of Justice received all this docket file, and they automatically send information to the court in Florida, in the Okaloosa County. But they saw the information because it was very clear. The central authority told these judges to stop the procedure of because during the procedure there was also to stop the divorce procedure, because it needs to be clarified the domicile of the mother, if she's not a real legal citizen in the U.S. or have the means to be tried in the U.S. Because if the court has a jurisdiction, it should go back to Spain. According to, there's another convention of the Hague Convention related to when the divorce, if the last domicile is Spain, the Spanish courts have the jurisdiction. Even though that the court decided to continue, they go forward over the divorce and the child custody of the boy. And then, according to the law statute in the U.S. in Florida, for having child custody, because childs are considered also as property in the legal system of the U.S. So you need to have a hearing related to how the boy is going to receive the visitation of one of the parents whom is going to live, so on. That if you see the docket file, that doesn't appear. There was no hearing about that. The judge arbitrarily decided to give to the mother the child custody over him. And then because it was a judge seeing the divorce, and then there was another judge, it was a magistrate from a civil court, seeing the Hague petition. Well, also here it was very strange, because all these judges are from the same county, this judge who decided that they present all documentation, even the transcripts were very clear that the father was in Spain, the left behind parent. He shows all the documents, even though that the judge, and it was very crazy. I mean, the judge didn't know the EU treaties, that even though if the boy is a German boy and he's born in Spain, he's not an alien. He's part of the system. I mean, he's, according to the Spanish law, he's a citizen. He's considered a citizen. So the judge decided no, he has no Spain has no jurisdiction. She denied the motion of the father, and well, she acts against the treaty that have of the Hague Convention related to the first state. So then, seeing all of this and doing a little bit more deep research related why this occurred in Florida, going more like a PI. What I discovered is that during this hearing of this case, all these judges, they needed, I don't know, they need to get like an amount of sentences until the end of the year, because next year they were going to be re-elected. So that was the case. They decided to, they didn't care about the law in this case, and they decided, because they have an election next year. And also what I discovered during my investigation here is that the family court system in the US is like a business. They have a very, very sick perverse incentive related to having the divorce. If they have a more amount of divorce sentences, they receive money from the government. And if they have more child custody hearings, they receive more money. And that,
all right, excuse
yes.
Attorney Marotta, I didn't
Yes.
intend to rudely interrupt. I could see Professor Alessandro indicating maybe she wanted to make a contribution to something. So if you allow the other party also.
I was intrigued by the presentation about this case of child abduction, because part of my studies are devoted to private international law issues, and so it triggered some other legal reasoning into my mind. Indeed, it is a very interesting case, and I thank Professor Marotta for explaining that. That was all. And I was surprised, I mean, not surprised, but I was a bit shaken when by the assertion that these judges in US court deal with cases not with other aims in mind. I don't know what they do there, but we have big issues about our higher judges here in Italy, with political discussions going on at the moment. And the Tribunal of Perugia, my town, is the one who was in charge of the whole thing. So this is indeed a sensitive issues, but it's not what I wanted to comment on.
Thank you.
That's very interesting.
All right. Yes, Prof.
Yes.
As you mentioned something about the US, I could see that probably the expert Taldi might be in need of saying something.
Yes.
Probably. So you'd want to come in some?
It's not a case I'm familiar with, and so no, I defer to those involved on it.
All right.
Let's go back to the ICC. After all, divorce is not a crime. Child abduction is, but divorce isn't.
Yes.
No,
all right.
Anyway.
Sorry for the disruption. Okay, but thank you very much. I didn't intend to interrupt. Only that problem. Now we need to portion the time so that they also make presentations. I might want to have more of that discourse going on. Then we link it up with the other aspects of our colleagues. I'm not actually putting you off, I'm just indicating.
No.
We might
Yes,
need
no
to
problem.
bring it and intertwine it with the other aspects of the prospects and challenges that the ICC is also facing. I see these are some of the challenges in respect of the US jurisdiction. So just proceed. It's okay.
Okay, so what I found here is that if what we learn about the former ICTY related to joint criminal enterprise, what I found here, it was a very what I name it. It was a co-perpetration based on joint criminal enterprise. I mean, here you see in some way each judge, knowing or not knowing, by doing it, if they have a knowledge about this, or they work separately, they joined in a way like in culpable negligence, not doing their job under the rule of law. They have this outcome because the boy, when the divorce sentence appeared, in the divorce sentences, the judge decided that the boy has to go with the mother, and the boy was moved to the mother moved to Utah, to another state. And according to the federal law in the U.S. And the Florida law, if the boy was going to move from Florida to Utah, it was needed a hearing related to child custody, and that doesn't appear in the docket. So,
Yes.
in some way, how because of this pressure of they need I don't know how many sentences to be reelected, they decided, okay, it's another case of child custody. Who cares? Next judge, or in Utah, it gets resolved. So that's a problem right now in the U.S. Jurisdiction related to, under some circumstances, judges act like a joint criminal enterprise if they didn't want to do it. And thanks to the work in the ICTY and the work right now that is going on in the ICC about the case law, all the research, it gives us I mean, not the weapons, I mean yes, the legal weapons to resolve the kind of cases and to narrow it, because I've been doing some research in the U.S. criminal case law, and there is a case law from, I think it's from Texas, that is related to joint criminal enterprise, and the judge resolved a case. I mean, it was related to a business in Texas, to cattle business. The judge uses the theory of joint criminal enterprise. So in the U.S., you can see that even though the U.S. doesn't, it's not part from the ICC, they use in its own courts. They use a lot of information and case law and doctrine related to joint criminal enterprise. That's what is going on here, and it's not the only case, because we have another one from a Philippine mother. She's now in Australia, and this
All right.
it appears on the same in Chicago.
Anthony Marote, you'll just excuse me. We now have Professor Sripathi. May I just interrupt so that I introduce him to the millions of our audience that are watching, wherever they're watching. I will unmute him. Okay, ladies and gentlemen, distinguished panel, we now have with us Professor Dr. Dwarath Kanath Sripathi. is here with us, and I would like to make a very brief introduction so that we are able to straight away. After this, I'll request that we get one of the other panelists to come in so that later we link it up to Professor Marotta. Okay, Professor Dorat is a professor of international law and is based in the Asian continent. He's been a professor, he's been head of law department, he's been dean, he's been vice principal, and he's been principal in those universities. He's been actually in the legal academia for the past over 3 decades, 30 years. And he's an expert in areas of international criminal law. He's participated in a vast number of conferences and presentations and seminars in matters related to sorry about that. I don't know where it's coming from, but we control it. So Professor Siripathi has written several papers in the area of international criminal law, and is a respected scholar and academic. Welcome, Professor Siripathi. Can you unmute you? Okay, I've unmuted. Welcome to the panel.
Thank you, Professor Milton. Thank you so much. And my greetings to all the other panelists. Hello.
Hello. Nice to see you in the face of COVID-19. Okay.
Yes.
Attorney Marotta, with your permission, you'll allow me to usher in the contribution of the other professors so that we are able to fuse the very good presentation you're making so far.
Okay, no problem, yeah.
Oh, thank you so much for that. We still need to get more of what you're saying. But now I'll invite any of the 3 professors who are with us, Professor Alessandra, and anybody else who is able to present right now to proceed. Thank you very much.
Thank you.
Thank you. Maybe I can just say something, just follow up of the introduction made by Professor Dr. Milton before, if you allow me. Also because I'm afraid, but at 4:30 my time, I have to leave the meeting as I have another commitment. I'm sorry, but
no problem, no problem. That's how it was scheduled, yeah.
I'd love to discuss issues of private international law, but not today. Maybe we can convene another webinar. Let me thank Professor Dr. Milton for organizing this webinar and for inviting me to participate in it in such dire times. As he said in his presentation, I teach international law in the Faculty of Law of the University of Perugia. Perugia is a small city in central Italy, and its university is more than 700 years old. Luckily enough, the region where I am now was not hit severely by the COVID pandemic as other regions in northern Italy. But we are still semi-self-confined at home, and I'm talking from home now. As an international lawyer, my involvement in issues related to the ICC and to international criminal justice began exactly in 1998. At the Rome conference, where I was invited to participate as a legal advisor. And in that capacity, I followed many, if not all, of the meetings from the United Nations Diplomatic Conference in Rome, and later in New York, the Preparatory Commission meetings, and those of the Assembly of States Parts, which is the administrative body of the International Criminal Court that took place in The Hague. So I would start just a short comment on what Professor Milton said before to introduce the issue to the public, to our virtual public, that is that the statute was approved by a large majority of states, and that only at the diplomatic conference that night of 16th of July 1998, I was there, where really many, and just seven delegations, 7 states voted against the approval of the text of the statute, meaning of a treaty that established an international criminal tribunal. And I would start my reflection on that, in the sense that here we have the first international criminal tribunal where judges and prosecutors can operate according to a set of rules and a law that was codified well before the occurrence of the crimes. The International Criminal Court, as was said by Professor Milton, is a creature of the statute. The statute, all its ancillary instruments, namely the elements of crime, the rules of procedure and evidence, and other elements, hence provide a predeterminate and clear guidance. This guidance should be actually unequivocal, but as any piece of legislation, it is subject to interpretation, and it can be sometimes misunderstood or misinterpreted by some. Besides, those rules, almost all of them, you mentioned before, joint criminal enterprise. Also, this issue was discussed with regard to the text of Article 25 of the ICC statute and of the corresponding rules of procedure. Many issues at the end were the result of a compromise solution, a compromise reached among different views, different opinions, different people with different legal backgrounds, not only of different political views, because they represented states. So the point to highlight to me is that this system created by the International Criminal Court is a statute-centered system. That is, the ICC is a statute-centered institution because it was created by a treaty approved among sovereign states. This means that the ICC is has many flaws, many things which could go better, because it is a state-centered organization, a state-centered institution. It is true that for the first time, a tribunal operating at the international level was created, independent, autonomous from states, and that the judicial dimension should prevail. But we have the political dimension, which cannot be forgotten, because having its legal basis in a treaty, namely the statute, the judges of the court cannot develop law autonomously, and they are bound by what the statute says. So only states parties could adjust, modify, amend the statute. They have done in small part. At the beginning, the creation of the Rome Statute was welcomed with a lot of enthusiasm, and from states coming from different areas, geographical areas, political areas. It was welcomed by, let's say, a cosmopolitan mindset, if I can say, in favor of the establishment of a supranational court of last resort, with a common goal that to put an end to impunity, as you know. And I remember the group of like-minded states, states that pushed towards the entry into force of the statute, and which also included South Africa, if I recall correctly, and also my country and many others. Then I say, after more than 20 years after the adoption of the Rome Statute, now the ICC suffers from an ever-growing legitimacy deficit. It is the subject of many criticisms. So I wonder, where does it come from? How could this initial very positive attitude have changed so much? And we can see many criticism, and criticism goes into opposite ways, as for instance, the trigger mechanism, the motu proprio initiatives, investigations by the prosecution, the issues with cooperation. Of course, my time is almost expired, so I cannot deal into that. Maybe another time. I don't want to finish my time. What I think is we should, there are many issues, the selection of cases, difficult for the prosecutor to conduct meaningful investigation on the ground, problems with cooperation because, as you know, the court has not constrained power within the territory of states, and many other questions which can be summarized in a dyadic criticism: independence, dependence, independence of the court, dependence from states, because states are those who finance, the states form part of the administrative body of the court, the Assembly of States Party. So the judicial dimension has to cope with the political dimension of the organization, and this brings inevitably a lot of criticism. And I could say more about this point that I just mentioned, but time is expired. And I like to think that, as I say to my students, I like to see the glass half full rather than half empty when talking about the International Criminal Court. It is full of flaws. There are many points which should be improved. But the paradox is that all its decisions can be seen as flawed in some terms. But this does not per se undermines the necessity of having the International Criminal Court. I thank you for your time.
Okay. Professor Lasciotti, thank you very much. I believe my colleagues will agree that was a very erudite presentation. It's only the question of time. I know you've mentioned a very critical point here, that the operation of the court itself is characterized by some form of paradox. And also I've noted that you say the judicial arm of the International Criminal Court are influenced by a number of factors. It cannot be divorced from the political influence, and that element of financial independence. Those are very good points in connection with the challenges. I believe my colleagues will agree with that. So colleagues, thank you very much, Professor Lanciotti. We can still have you after my other colleagues have made their presentation.
Maybe another time we focus on specific points, but I didn't know what the audience is. So just stay general.
Good, good. Actually, that's a very good point. We meant to have it a more general approach so that each of us, like you can see that what Dr. Marotta brought in was very critical about the criminal enterprise. It was to allow an all-embracing approach to it. Our next discourse might focus on specific issues. Like next week on Thursday, we should be able to have a focus either on the United States of America and the ICC. So that might be a more focused area. Thank you very much. We've really had a good time with that presentation as well as that of Attorney Marotta. Now I would like to hear from the other distinguished legal personalities with us. Any of the two of you could come in.
I'll start, I think, if that's all right. And I'd like to pick up on one thing that each of my distinguished colleagues talked about in their presentation. But before that, since we're talking about international criminal law and atrocity crimes, I thought we ought to note that today is the International Day for the Elimination of Sexual Violence and Conflict. It's a day that we set aside to talk about a particular category of atrocity crimes, crimes against humanity, war crimes, if committed with the right intent, acts of genocide under ICTR jurisprudence. And a category of
thank you for that. Thank you very much for bringing that up.
And a category of crimes that at ICTR and ICTY have been an enormous amount of the focus of the investigative and prosecutorial work. That said, and quite briefly with respect to Professor Sripati, who still has to speak, I wanted to pick up on one point that each of my colleagues had offered. The first two, kind of as a framing mechanism for thinking about the prospects and challenges of the International Criminal Court, emphasize something Professor Lanciotti said, which is it's a treaty body. That is, it's an international criminal court, not a global criminal court, because it exists within the existing body of law about what treaties can and cannot do. And when we're evaluating its prospects and challenges, if we're trying to do that fairly as observers and as supporters of the mission of ending impunity for the world's most serious crimes generally, we ought to be fair about our expectations. And so it exists in a context of, for instance, the Vienna Convention on the Law of Treaties saying treaties don't bind non-parties. Full stop, the end. And so China, for instance, has chosen not to sign on to the Rome Statute. They have no obligation to the court or under the court. And the same is true for other non-party states. And when we think about its relationships with different countries, it's important that we understand that it is existing as a treaty body in that specific legal context. It's different than the relationship that, for instance, the South African courts have with citizens of South Africa, or the United States courts have with citizens of the United States, because international law is different. And that creates some of the challenges, I think, that it faces, because it's easy, I think, for someone accused of a crime there to suggest that this basic feature of international law is in some way unfair to the people whose countries have signed on, when in fact they've consented, they've given over jurisdiction, and it draws its legitimacy from the consent of their perhaps predecessors in government who signed on to the treaty and agreed to be bound by it. And when dealing with a non-party state, it's a very different issue. Then the second thing to pick up on maybe is to think about, because joint criminal enterprise has been a big part of what we talked about today, how that functions and what ICTY and ICTR were and were not doing in developing the law of joint criminal enterprise. And so the basic thing is to understand the concept. And with apologies to old Saturday Night Live characters, perhaps, a joint criminal enterprise is first an enterprise. That is something you try to do. Second, which is joint, involves one or more people. And third, which is criminal, which entails as part of its purpose, the commission of one or more crimes within the jurisdiction of the court. And what ICTY wasn't doing in developing that was trying to set out what co-perpetration jurisprudence would look like in every domestic jurisdiction in the world. But it was saying, here's how we're going to apply co-perpetration based on what we're able to identify in customary international law from the trials after World War II and elsewhere. And it requires that everyone involved both share the intent for the crimes and make a significant contribution to the commission of the crimes in order for them to be held responsible. And it's important to remember that in the context of thinking about what may or may not satisfy those legal requirements. For instance, we wouldn't have been able, if the only thing we had evidence of was culpable negligence, to show somebody was a member of the joint criminal enterprise. And we also wouldn't have suggested that the courts of Italy or the Netherlands or the United States or India or South Africa were bound to apply that specific version of co-perpetration as opposed, for instance, to Article 25 of the Rome Statute or conspiracy law in the United States, or what Germany, I think, refers to as the perpetrator behind the perpetrator.
Yes.
A version of the German language that I can't possibly hope to pronounce. It's an example of how these courts are developing very slightly different approaches to similar legal concepts. And the basic idea that the Cottage Chamber was considering was, does international law recognize this idea of co-perpetration? And it said yes, and ICTY has set out a lot of the lead law in applying that to leadership cases, leadership level figures who were allowed or who were found to have engaged together in enterprises commit widespread and massive violations of criminal law. I think there's a fair bit from our work that ICC can benefit from in terms of looking at the technical details of how cases work, the need to establish patterns of conduct by subordinates, the need for robust access to and evidence based on documentation, official documentation that allegedly committed the crime, to understand how they function, to be able to prove effective control. And going back to the thing that I said at the beginning, and to acknowledging the importance of this particular day, to looking at different types of victims of crimes, whether it's children, as Giovanni works with, or victims of sexual violence who we remember today and accept anew the obligation to work on behalf of. So given the time, I think I'll leave it there and turn it back over to Dr. Milton.
All right, that was very erudite again. Attorney Traldi, thank you very much. You've talked of very critical issues about the treaty. The treaty parties get bound by what they commit themselves to. And so that brings in the issue of, as I said, in the next panel discourse, we're going to look at the relationship of the United States of America and the ICC. USA as a non-party to it brings in very critical issues. Just like Professor Lanciotti indicated, there are other elements like the political influence on the financial aspect. We know the United States has wields amount of influence that can, so we need to look into that in our next discourse. Thank you very much. We appreciate it. Okay, now we have Professor Sirapathi. You are not here when we started. But we say, we welcome you, Susandia. We greet you, Susandia. Now it's your turn. You may give us your presentation, sir. Thank you, Prof.
First of all, a big hello to all the panelists. And I also would like to thank Professor Dr. Milton for inviting me and giving me this opportunity of presenting my views on ICC, prospects and challenges. Now, the establishment of an international criminal court in the world started after the First World War. In the sense, when the League of Nations was established in the year 1920, and while it functioned as an international institution for the purpose of maintaining international peace and security, two conventions were signed under the auspices of the League of Nations. One convention was on the suppression and repression of international terrorism, and the second convention was on the establishment of an international criminal court. So right from 1937 and much before that, efforts have been made by the states in the international community to establish an international criminal court. Unfortunately, in 1939, the League of Nations was dissolved and the two conventions never saw the light of the day. Then after the Second World War, the crime of genocide came into prominence because it was committed by Adolf Hitler against the Jews. And in order to punish the war criminals of the Second World War, we are aware of the fact that two ad hoc tribunals were established. One was the Nuremberg Tribunal and the other was the Tokyo Tribunal. Now, these tribunals were temporary in nature, and a lot of criticism was directed towards the tribunals in the sense the tribunals were branded as white tribunals because the judges of the tribunals came from the victorious powers. And the jurists in the world have stated that there cannot be any kind of fairness. The accused would not have a fair trial and the tribunals would be biased. Then coming later to the 1990s, where two criminal tribunals were established by the Security Council, that is the ICTY and ICTR. Now, these are also temporary in nature. However, these two tribunals have done justice to the two states by punishing the accused. And then after so many years, the states again thought of having a permanent institution like the ICC, and therefore negotiations and deliberations started. And the deliberations culminated in the drafting of the Rome Statute, 1998. And then in 2002, the ICC was established under the statute. Now, as it was pointed out by Professor Lanciotti, that the court has a lot of faults, defects. And one fault that I would like to point out is that the range of crimes, there are 4 in number, which the statute speaks of. Firstly, genocide, then crimes against peace, crimes against humanity, and war crimes. Now, of course, we'll find a long list of all these offenses under war crimes, crimes against humanity, crimes against peace, under the 4 Geneva Conventions of 1949, which have been taken straight from the conventions and incorporate it into the statute. And therefore, I feel that the jurisdiction of the court is limited. When we speak of an international criminal court, it is not enough for the court only to try war criminals. There are so many other crimes, international crimes, that are being committed by individuals in the world. And these crimes are being tried by the national courts in the country. And since the crimes have an international element, some of the accused criminals are going scot-free. So this should not happen. So that is one big drawback for the International Criminal Court. And then coming to the composition, we do have the presidency and then the trial chamber and the pre-trial chamber, the prosecutor's office and the registry. Now coming to the prosecutor's office, the prosecutor can take up investigations voluntarily. However, after the approval of the court, he has to take the approval before he starts an investigation into a case. Now, states can refer cases to the court and also the Security Council. States voluntarily, when they refer cases, there are no issues. But in respect of cases being referred by the Security Council to the court, creates a problem because the Security Council is being selective. The Security Council is not referring cases which are happening in other countries. Now, this is one big reason why the African continent is against the ICC. All the countries in Africa feel that the Security Council referrals are being partial. The African continents, the states in the African continent, that is maximum 33 members come from the African continent, and they expected a court at the time of the signing of the statute, a court that would be universal, impartial, based on sovereign equality and universality. But however, today, the African states feel that this is not happening. The court is showing a lot of impartiality towards the African countries, because out of the 10 investigations before the court, 9 investigations relate to African heads of states. Now on paper, this might look as something being very partial, but we should also understand that the court has been established for the purpose of punishing criminals, and that is the primary objective of the court. And if the court has indicted certain heads of states from the African continent, I do not find any fault with the court. However, the fault lies with the Security Council, because despite petitions being made by the African countries to the Security Council to defer certain trials against African heads of states, the Security Council refused to act upon such petitions. And this further annoyed and infuriated the African countries, particularly the African Union. Now, while the African Union and the African countries expected a court that would be independent, and the court is independent even today. We cannot question the independency of the International Criminal Court. While the African countries expect the court to be independent, why are the African countries trying to subject the court to an advisory opinion of the International Court of Justice? On the one hand, they want the court to be independent. On the other hand, they are subjecting the court to another court. This is something that is contradictory on the part of the African nations and the African Union. This is something that is not right. At least I feel that way. I do not know about the opinion of others, but this is what I feel. And they also expected the prosecutors to be partial. This was a concern of the African state at the time of the signing of the statute. And that concern came true today. The prosecutor is accused of being partial as far as the African heads of states are concerned. And therefore, even the Security Council has inconsistently exercised its powers as far as the ICC is concerned. And why did this discontentment come as far as the African countries are concerned in respect of the International Criminal Court? Now, as I said, the African countries are not happy with the functioning of the court. And apart from that, they're also not happy with the Security Council. And therefore, there has been a lot of non-cooperation on the part of the African Union and some of the other African countries. In the sense, when an investigation was started against Omar al-Bashir, the president of Sudan, and the ICC issued an arrest warrant against him. And all the countries, other countries of the African continent, which are parties to the statute, have an obligation under the statute to arrest him when he's found on their territory. But this did not happen. A lot of countries allowed the president to move freely among the African countries. So this is a kind of a non-cooperation on the part of the African countries. And apart from that, a lot of countries, African countries, have decided to withdraw from the membership of the ICC. Particularly Burundi, South Africa. Burundi, of course, has been successful in withdrawing its membership from the ICC, but South Africa was not successful because it was prevented by the High Court of South Africa to revoke its notice of withdrawal. And also the notice of withdrawal on the part of the South African government not give any valid reasons why it would like to withdraw. And I do not want to go into the constitutional issues that exist in South Africa as to how a high court can prevent a government in performing its sovereign function. Because there could be provisions in the Constitution of South Africa where the judiciary is allowed to prevent such such sovereign functions. Now, coming to the prospects of the International Criminal Court, the 7-year clause, which created a lot of apprehension among the states at the time of the signing of the statute. The states felt that very soon a lot of states would withdraw from the court and the court would fall, but that did not happen. So this clearly proves that the court is still popular. Despite the discontentment shown by the African countries, the court is still popular in the world. Only 2 countries have withdrawn from the membership of the ICC. One is Burundi and the other is the Philippines. Now, since the membership remains intact, the court has a bright future, and the other aspect that I would like to dwell upon is that the court should increase the kind of crimes that are being committed by criminals in the world. It cannot restrict itself to just those 4 war crimes which are normally committed by heads of states at the time of war. There are so many other international crimes. So the court would do well if it can bring under its jurisdiction all the various other crimes like human trafficking, drug trafficking, and money laundering. These are all
Piracy.
terrorism, international terrorism. These are all crimes that should be brought under the purview of the ICC, and only then the ICC will become more popular. And as far as the African countries are concerned, I can make a suggestion in the sense the African countries, if they're not happy with the functioning of the ICC, they can go for hybrid courts. Hybrid courts. This is something that happened in 2002 when, after a 10-year conflict in Sierra Leone, the government of Sierra Leone requested the United Nations to establish a court where the court would have international judges as well as national judges of Sierra Leone. And the law applicable also would be international law as well as national law. So this probably can help the African countries in the near future. So this is what I would like to say and conclude my discourse. And I thank all the other panelists for giving me a patient hearing. And I also thank Professor Dr. MILTON for, once again, profoundly, for giving me the opportunity of presenting my views before you all. Thank you so much.
Thank you so much, Professor Dr. Sripathi. That was erudite. We see that you focused a lot on the Africa and the ICC. As I said, on the July 25th, we are going to focus on one continent, the United States and ICC. On June 25th, that is, next week, Thursday. Yes. July 2nd, we are going to focus on Africa and the ICC.
What time on the 25th? Sorry, on the 20th, meaning Thursday.
Yes, we are trying to get this time, but we, between us, the panel, we might propose.
I maybe join you later because I have another meeting before. But anyway,
All right. Prof, you will send me your suggestion, then I should be able to accommodate it so that we're able to accommodate everybody. No
Thank
problem.
you so much. I'm sorry I have to leave, but I have a meeting now. Thank you very much. I really appreciate it.
And thank you for bringing in the argument of the joint criminal joint enterprise that Attorney Marotta brought in. And thank you to Attorney Valdi for bringing in that aspect. You all made very brilliant presentations, very erudite. We can see really that there is a lot to be done. And Professor Sripathi, thank you very much for introducing the idea of the trigger mechanism challenges and those unique issues that Africa is confronted with. I felt that was quite critical. That is why we are devoting a whole debate to that. This course on July 2nd.
Professor, if I could, before we finish, I just wanted to note 2 things in regard to what Professor Sripathi was talking about. The first is, I think he's very eloquently described the challenges and controversies around those trigger mechanisms. It is worth remembering that there's only ever been one Security Council referral.
Sorry, we're just allowing us to, we can continue for those who are able and like the Prof indicated. So feel free to be able to bring in your contribution, including Marotta. Remember we did so just feel free. And if you want to leave, you let us know. Thank you, Attorney Traldi. Proceed.
Thank you. I think it's worth remembering there's only ever been one Security Council referral. The great majority of the investigations in Africa are investigations in countries that have signed on voluntarily to the court and accepted its jurisdiction. And if you're, for instance, a victim of the Lord's Resistance Army in Uganda, you might perceive the court's attention to your country as a benefit, not as a harm. And then second, though it's not the core of our point, just to note that I think most folks who've studied Nuremberg look at, for instance, the acquittals of some defendants as confirmations that they got fair trials there. And finally, to agree with Professor Sripati as well about the value of ad hoc tribunals, and in Africa to note not just the Sierra Leone court, of course, but the extraordinary African chambers that did the Hussein Habre trial that's been in the news this week as well. And it's worth all of us remembering, I think, that the ICC, as Professor Sripati eloquently reminded us, is just part of the architecture of international criminal justice. It's a specific court with specific members and a specific subject matter jurisdiction, but it's not the whole story. And African countries have successfully found other creative solutions when those were more appropriate, both in Sierra Leone and in Ghana.
Thank you, Professor. Traldi, is that all? Is there something you want?
That's all for me, yes.
Thank you very much.
Everyone.
Do we have any other contribution
Yeah.
towards what Professor Sripati indicated? Probably Professor Lanciotti may give us a parting shot before she just disappears. I hope, Tony Marotta, you have something as well.
So sorry, but I have to leave the house to go to play and have a meeting for real after many days.
Okay. Yes. We understand.
Commitment as well, but thank you everyone, and Dr. Milton, thank you for.
Okay, thank you both.
Thank you.
Immunity issue is another issue that is linked to the problem, to the dyad between the political dimension and the judicial dimension of the ICT operating. I'm sorry, distinguished speakers, I'm really sorry, but I have to go outside.
No
Thanks
problem.
very much for that argument of political influence and financial influence. It's coming up in the ensuing debate. And I can see Professor Aldi and Prof. and Marotti would be ready to be able to talk about that in the United States.
Any issue, you can feel free to contact me anytime.
Thank you very much for that erudite.
Thank you.
Thank you. Thank you.
Thank you, Professor.
Thank you again, everyone. Thank you, Dr.
Thank
Milton.
you.
Thank you, everyone. If there's nothing else, then I declare this expert panel discourse coming to an end. Thank you very much, millions of viewers all over the continents, wherever you are in the world. It has been a pleasure to have you during this difficult time. We see you again next week. I will be able to announce this on our LinkedIn profile. And thank you so much for those who participated. That is all for now.
Thank you.
Bye-bye. Thank you very much.
Bye. Thank you. Have a nice day.
Bye. Thank you.
Bye.
Nice evening for Professor Sripati. Bye.
Thank you so much. Bye.
Bye.